Hello, and welcome to Navigating the Estate Plan with Caress Law. Today's topic is all about funding the revocable trust. Funding essentially is the homework that has to be done once you create your revocable trust in order for your plan to work as intended, which typically means you are avoiding probate, you're keeping your financial business private, and you are helping your beneficiaries who survive you from being able to navigate this process of administering estates after death a little bit more smoothly. And the reason I chose this topic is mainly because if this does not occur, if your homework, this titling of your assets does not occur after you created the trust, you really haven't put your beneficiaries in a better position by creating this trust. You're still going to make them go through probate if it isn't funded appropriately. And it can cause a lot of expense, which creating a revocable trust actually reduces the probate costs because we avoid that process. And overall, it tends to be a less expensive option. I'm Tammi Caress. I am founder of Caress Law, and we're going to get started on this topic today. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. First, I'm just going to talk about what assets should be titled to your revocable trust. Essentially, any asset that is a probate asset should be titled to your revocable trust. And I will go over what a probate asset is. However, I do have episodes that talk more thoroughly on the probate process. And we will have those episodes in the show notes below, so you can refer back to those if you need to. Essentially, a probate asset is an asset that you own, and it is not jointly owned with rights of survivorship with anybody else. And there's no beneficiary associated with that asset. So very common assets can be a bank account. You can have a bank account. It's in your name. There's no payable on death designation on there. That's a probate asset. It could be a house. You purchase this property. Your name is the only one on the deed. That is a probate asset. Okay, so I'm going to get a little bit more specific about the types of assets moving forward. But I mentioned before, the types of assets that should be titled in your trust are things like your cash accounts, so checking accounts, savings accounts, money market accounts, CDs, certificates of deposits, should also be named in your trust. Securities. And when I talk about securities, yes, you may have some paper stock certificates if you have some really old ones, but usually today we have an account at Schwab, a Vanguard, even a Wells Fargo, that is a brokerage account that holds assets or stocks and bonds, those kinds of things. So when I say securities, that's what I'm talking about. Your real property, and real property are things like your home that you live in. If you have a rental home, if you have a vacation home, those types of assets should be titled in the name of your revocable trust. Your household items, we call it tangible personal property. So tangible personal property assets, I always say the things you can touch and feel inside your home should be owned by your trust. Those things are art, jewelry, furniture, basically anything inside your home that you can touch and feel, or even outside your home. And we do those informally, typically by an assignment. Usually when you go through your estate plan, we do that for you. So it's not as if you have to go through and list every single item in your home and figure out how to title it to your trust. No, we usually do a general or a general assignment for those. Other assets are things like business interests. If you have an LLC, a limited liability company, we assign that membership interest in that limited liability company to the trust. If you have a S Corp, we will assign that an S Corp is a shareholder or even a corporation. You're owning shares in the company. You might have a majority ownership in the company or own 100% of it. But we are changing those shares so that the trust is the owner. Some other miscellaneous things are timeshares. This is probably the one asset that people forget to tell me about, are their timeshares. And we want to make sure the trust is the owner of those, or we have some sort of alternatives if for some reason a trust cannot be an owner of those. Typically, we are looking at the actual timeshare agreement to figure out how we get the ownership to the trust. Okay, so there are a lot of other assets that typically are not in the name of the trust, and I actually am going over those in my next episode. So if I didn't list them out here today, it's probably because generally they're the type of assets a trust will not own. However, I'm going to add one more to our list that a trust may own. Those are vehicles. Now, there's usually, I know there is in Oregon and Washington, there is an easy way to transfer title of vehicles once a person has passed, and we can avoid that probate process. But depending on your specific circumstances, you may want to title those vehicles in the name of the trust. You may not need to, but you may. So it depends. It really depends on your individual circumstances. That's something that if you're working with me, I would talk to you about. If you're not working with me, definitely bring it up with your estate planning attorney. So the first thing to do when we are placing assets in your trust, every asset is going to have a different way to go about it. But the first thing that we do when you create your revocable trust is we also have you as that trust creator and also the trustee of your revocable trust. We have you create what's called a certificate of trust. Now, if you have already created a trust, you may already know this, or hopefully this sounds familiar, but a trust, one of the advantages of a trust is it keeps things private. When you go through probate, it is not a private process. It's a very public process where anyone who wants to can see what you owned, who your beneficiaries are, what your debts are, and so on. So another advantage of a trust is the privacy aspect. So that we want to maintain that privacy when you go through your homework of titling assets to your trust. And we do this by using a certificate of trust, which is a completely valid document under Oregon and Washington law and in most jurisdictions. And essentially, it's a document that says, yes, I have a trust that is in existence. It is a revocable trust. It names the trustor, which is also called the grantor or settlor, depending on your jurisdiction. That's the trust creator. It names the trustee. It names the address. It provides the tax ID number for the trust. And typically that tax ID number is your social security number. And it also may list the powers of the trustee. So when a company, and it's usually a financial institution, asks for a copy of your trust, you don't have to provide them a full copy. Your trust is private. No one needs to know what it says. Not only that, the trust is revocable, which means you can change the terms of that trust at any time. So giving something, a copy of something that can be easily changed and likely will be as time moves on, is pointless in my opinion. So, and just a disclaimer here, if you have a financial advisor that you work with that wants a copy of the trust, I think that is completely appropriate for them to have a copy. But if you're just going into your credit union and you just have a checking and savings there, you have no one in particular that you work with or manages assets for you, then they do not need a copy of your trust. Instead, you can provide them with the certificate of trust. And in it, the bank financial institution just needs to know who the people are under the trust that have all the power. And that's the trustee. I mean, the trustor and the trustee, but if you've listened to prior episodes, you know that the trustor and trustee typically are the same person. Trustee will change later on, but when the trust is created, usually the trustor and trustee is the same person. So the bank or financial institution just wants to know who is the one who has authority to withdraw money, deposit money, make decisions about the account, and so forth. And that is the trustee. In your trust document, there should be an article, at least I have an article, that defines what the powers are for the trustee. And that's basically what they can do on behalf of the trust. For example, sell assets, open bank accounts, even make loans, even take loans. There's lots of trustee powers. And essentially the bank or financial institution just wants to know that the trustee has the power to open this account and also make decisions regarding the account. So oftentimes, they may ask for more information if you give them just the certificate of trust. The only additional information they will need are the trustee powers. In my trust, we always attach the first page and signature page of the revocable trust to that certificate of trust. It's typically enough to satisfy the financial institution. But if they want a little bit more, we're just giving them a copy of those trustee powers, which is not disclosing all of those private details of the trust. It's just informing the financial institution the trustee can act on behalf of the trust. Now, the certificate of trust is prepared by your attorney, but the financial organization may have their own certificate of trust that they want you to fill out. That is perfectly okay. It's just the information they want in lieu of providing them with a full copy of the trust. So the certificate of trust is an important document to have handy if you want to keep the trust terms private. Next up is I'm going to go through that list that I went through before and talk a little bit more in detail about how we deal with those types of assets. So the first asset on my list are those cash equivalent assets. And I am referring to your checking, savings, money market, and CDs. Essentially, going to the financial institution when you just created your revocable trust means that you hopefully can keep your account, and all you are doing is just changing the name on that account to your trust. It should be just some paperwork to fill out. Now, when you open an account or you have an account, the financial institution has your social security number, which is associated with that account and tied to it. When you have a revocable trust, you don't need to get a new tax ID number. You are keeping it under your social security number, and that's because it's a revocable document. You can revoke it or change it at any time, which hopefully means that the financial institution will allow you to just change the name. There's many that will, because really it's the social security number on the account is how they have to report to the government regarding income earned and interest earned and things like that. And you should be okay. So if you have an account where you have money going into by automatic deposits every month, and you have expenses going out of by automatic withdrawals every month, that will not affect those. However, just a disclaimer here. There are some financial institutions that have an internal policy that requires a new account to be opened. This personally is frustrating to me because everything is, record keeping wise is by the social security number, and that's not changing. So how you deal with this, it really depends. One is you may be dealing with somebody who doesn't understand. And unfortunately, that's just the way it is. And so you may want to ask if someone else can help you, maybe their manager. And that's, again, we just have a lot. Those, when you go into a bank and you're trying to do something like this, you're working with someone on the front lines there who typically that's where they start out with the bank. And they don't know everything. So sometimes it's just a matter of asking for a manager to help you. Now, it could actually be an internal policy of the financial institution. And if it is, well, then that is a painful process to have to open up a new account in the name of the trust, move all of your direct deposits and automatic withdrawals over to that. It is something that I would encourage you to do. There is an alternative. It's not my favorite alternative, but it is something that can work. And that is you can name your trust as the beneficiary of that account. So as long as the account is in your own name, not in the name of your name and your child. I have another episode in the past talking about why you shouldn't do that. But if you do have a probate account, a probate asset, which is a bank account, and the bank will not allow you to just rename that account, then you can name your trust as the beneficiary of that account. I personally don't like this because I think it just opens the door and offers more, it just gives more ability to make mistakes later on, especially if you become incapacitated or something like that. Your agent on your power of attorney would step in, and we want your trustee to be able to step in instead of that agent. So it just can cause a layer of complication. And if there's a layer of complication, more opportunity for mistakes. So not my favorite, but it is a solution. Okay. We talked about the certificate of trust and we talked about those cash equivalent assets. Now I'm going to talk about securities. I am talking about stocks and bonds. It is the same process that I just discussed regarding your cash equivalent accounts. You have your certificate of trust. You provide that to the financial institution. And hopefully they will just be able to change the name on that account to your trust and not require a new account be opened, and etc. Next asset is real property. Again, that's the home that you own. It could be a rental home that you own. It could be a vacation home. Nonetheless, it is a home that you likely pay some sort of property taxes on every year. Real property is titled to the name of your trust by a deed. When you buy property, you're usually at closing with the title company. You are not signing the deed when you buy property, but the seller of that property is signing the deed, deeding the house to you, if you will. Your house should be in the name of your trust. I take care of this for you as long as your property is in a jurisdiction that we're allowed to practice in. If it's not, we will help you find someone or a company to prepare a new deed so that we can get that real property in the name of your trust. Now, a lot of people grow concerned about transferring property to the trust. When it comes to your primary residence, you can transfer property to your trust, although it is mortgaged, and it is not going to cause a due on sale or triggering of that mortgage because you made this transfer. There is an exception when it's transferred to your revocable trust and your mortgage company. Now, there are some reasons why you may want to get permission from your mortgage company first. I always think that is a good idea. With your primary residence, it's not relevant. But if you own like a duplex or maybe a fourplex, I think it is, basically multiple properties that are under one deed, we may want to get a consent from your mortgage company. But I will consult you on that if it's applicable, or your estate planning attorney should consult you on that. But when it comes to your primary residence and even a single family home that you own, there's not going to be any issue with transferring it to your trust, although it is mortgaged. Next is your tangible personal property items. Now, you don't own a title to that plant you've had in your house for the last 15 years, right? But maybe this plant is given to you by someone very special, and you want to make sure this plant goes to that person at your death. Well, in order for it to get to that person, we need to put it in your estate plan. And if you have a trust, we want that trust to be the owner of the plant. It is simple. Your attorney, I prepare this, will prepare an assignment of your tangible personal property to your trust. I will not prepare an assignment just for your plant. By the way, it'll group all of those tangible personal property assets to your trust. It's pretty simple. Business interests. Now, transferring the business interest to your trust is heavily dependent upon what your business agreement says. So I always ask for a copy of your business agreement when I am going through the estate planning process with you. What I can tell you, because there may be restrictions in those agreements on how it can be transferred or whether consent is needed by other business members, et cetera, et cetera. But many people own a business. They are the 100% owner. And I'm just going to talk about what happens in that event here. So with a business interest, if it is a limited liability company, we will prepare an assignment of that membership interest in that limited liability company to the trust. It does not change who can act on behalf of the business. It simply is an assignment that you sign. And then when we amend or update, renew the articles of organization, we're going to tell the Secretary of State, whoever, whatever state organization is over the business corporations section. And we are going to let them know that the trust is the owner. It's pretty simple. When it comes to corporations, and we're talking S Corps, we're talking C Corps, if there is actual stock certificates, we will want to prepare a new stock certificate naming the owner of that corporation, the trust. If there's no stock certificates, a lot of times it's just on the books, and I'm doing quotes. I know you can't see me, but I'm doing air quotes with my hands. Then we will, on the books of the business, change the name to the trust. I usually have a shareholder, a form to fill out as a shareholder to make that transfer effective. Some other miscellaneous things like the timeshares, I am always going to want to look at the agreement with the timeshare company. You may have a timeshare that you actually have a deeded title on. That's easy. We just convey it to the trust just like we would with your home. But we usually follow the terms in those agreements to determine how to get the asset under that trust umbrella. Lastly, are vehicles. Now, like I said before, vehicles are, it just really depends on your situation. If you have two kids, they get along great. You can probably avoid, and everything's going out to them, you could probably avoid changing your title to your vehicles to the trust. Instead, there's an easy process for your children to do that once you're gone. But if you don't have any heirs or kids, and maybe you're giving everything to charity, then we probably in that scenario would want the trust to be the owner of that vehicle. That's simply so that the trustee can step in pretty easily and do what they need to do with that vehicle upon your death. So that is something to talk specifically to your estate planning attorney about. Finally, I'm just going to mention some of the assets that are not to be titled to your trust generally. Now, it's always specific to your circumstances, but those are qualified accounts, annuities, 401ks, IRAs, life insurance, the assets of your business, not the ownership of your business, but the assets of your business. And sometimes we don't want jointly owned assets to be owned by your trust. And these are heavily dictated by your specific circumstances. But my next episode is going to talk specifically about the assets that typically are not owned by the trust. So look for that episode to find more about those assets I just mentioned. Now, what happens when you fund all your assets to the trust? One, you can give yourself a big pat on your back. That is a huge feat. It is super important to do that. But once you are done doing that, you can go about your everyday life as you are now. It essentially means that if you acquire a new asset, you are not going to acquire it in your single individual name. Instead, you are going to acquire it in the name of your trust. Therefore, you won't have to go through these hoops again to get things retitled. If you sell a trust asset, there are no additional complications generally with that sell. You may have to show the certificate of trust. Say you're selling real property. You may have to show that certificate of trust, not the trust itself. And what happens is you sell your house, you take the proceeds from the sale of the house, and they are directed or deposited into an account that your trust already owns. Now, let's say you just sold your home and you're going to buy a new home. You're going to take those sales proceeds that are sitting in the account owned by your trust. You're going to apply them to your new home. And when the deed is being prepared, typically by the title company, I would really love it if you let me look at that deed before it's actually recorded. But the title company can place that title directly in the name of your trust and not your individual name. So once you go through the step of getting your probate assets and some other assets, but your assets titled to your trust, you're in really good shape, and it's business as usual when it's comes to your everyday life. Now, another question that people often ask me is, how does this affect my personal income taxes? It doesn't. With a revocable trust, everything is associated with your Social Security number, and the tax reporting or the income reporting that you do annually will not change and is not affected by the revocable trust. All right. I hope this is helpful to you. I just know how this is super, super important when you have or create a revocable trust. It's getting those assets titled to the name of the trust so that we can avoid probate. That's the action that has to happen. You can't just sign your trust document and say, I'm done. You are not. The next step is your homework of getting those assets in the trust. Otherwise, you are not avoiding probate, and you've actually increased the amount of money that will be expended in settling your estate and made it extremely complicated. So I am going to put some of our previous episodes in the show notes below that are relevant. I do talk heavily about trusts and probate in prior episodes. So if you don't know what any of those, what those mean or what that means, then I recommend that you go back and listen to those episodes. I also have a lot of resources available on my website. That is www.caresslaw.estate. And I'll spell it out for you. CARESSLAW.ESTATE. Okay, until we meet again, thank you so much.